once you get the law degree, they tell you for the rest of your life you have to write on a yellow pad.
This is standard, this is what is issued, we get from Home Depot pursuant to a city contract. I don't get into those details. I don't get in those weeds.
So we've silenced cell phones.
Thank you.
I just did it myself.
Thank you for having me in.
Sure. Thank you for coming in. Why don't you just start with laying out what the city is trying to accomplish here?
Okay.
Introduce yourself.
Okay.
I'm Nick Fish. I'm a Portland City Commissioner, and I brought this charter change to council. It was approved by the council, and so I'm here to defend 26194. Let me just frame this, if I could. This charter change arose because of yet another example in the sharing economy of an out-of-state company refusing to follow our rules and laws. So while Airbnb and Uber have been getting all the attention, HomeAway is right there in terms of same kind of approach to the city. HomeAway operates short-term vacation rentals, and they use a similar business model to the other short-term rental companies. And they're essentially an internet intermediary. They're an app. And when you go on the app, you can, they'll match, you, Rachel, with Nigel's Beach House, and for that, they get a fee, but they handle the transaction. So they're the internet intermediary. And they represent kind of the latest advance in technology. In 1970, the city, through its charter, set up a transient lodging tax. And the way it was worded is it said that if you operate a hotel, motel, apartment, or lodging house, mobile home, trailer park, or any place intended for lodging occupancy, city can tax you. Currently, we tax, through the transient lodging tax, we tax hotels, motels, beach, vacation rentals, and other things, 6%. 5% goes to the general fund, 1% goes to Travel Portland. County adds 5.5%. So the total tab is 11.5%. In 1970, the lodging business was basically bricks and sticks. Today, as you know, it has evolved to where a lot of the business is conducted through the internet, and some of the most successful companies are just apps. They're matchmakers. So we have been trying to regulate this new economy, the so-called sharing economy, and as you know, we've had mixed results. Airbnb, we estimate 80% of the apartments that they rent on their platform fail to comply with Portland code on health and safety.
Do people who are renting rooms in their house on Airbnb, do they pay the transient lodging tax in theory?
Yes, and that's a great point. So let me just say that HomeAway is such an outlier that this is one of those rare instances where I can tell you that even Airbnb pays the tax.
Okay.
So that's a great point. Airbnb collects and remits the tax on behalf of their hosts. And we have a written agreement with them. And I think that's important because Airbnb has not been, the best corporate citizen. But in this issue, on this issue of paying the transient lodging tax, they pay it. They collect it and they remit it. And while I don't use their website, I'm told that when you book something, it actually shows on your online invoice the 11.5%.
Okay.
and that's deducted from the amount of money that the guest pays, and then Airbnb remits it. So as they should, because 1970, Airbnb was the guy that ran the Motel 6. Today, Airbnb is an app that essentially matches people. So, Airbnb pays this tax, all of our hotels pay the tax, just about everybody pays this tax except HomeAway. HomeAway came into town and said, we're exempt from everything. They didn't register as a company, they didn't pay the business license fee, they don't pay the transient lodging fee, and they don't require their host to comply with local health and safety laws. They've hired whip-smart lawyers to make every argument under the sun: federal law, preemption, internet decency, everything you can think of. And we have been in extensive litigation with them. Recently, in one of our cases, a federal judge issued a ruling and said, I have a hard time thinking of them as an operator, as Webster's dictionary defines an operator. And the federal judge was thinking more like a bricks and mortar business than an internet business. So the judge said in his opinion, Judge Mossman, he said, I encourage the city to go update the charter to cover the new technology. So we thought about a number of approaches, and we settled on the approach that's now before the voters, 26-194. The charter of the city of Portland is like a constitution. And a constitution is meant to be a broad grant of authority. And we use our code to drill down and handle, specific cases. Right? The U.S. Constitution has sweeping language, not specific language. And then Congress legislates. Well, our charter has at section 7-113 a transient lodging tax provision, which we have by code interpreted for a long time. And based on advice of counsel, what we have put before the voters is an additional clause in our section 7-113 that grants the city council the authority to expand the application of the tax in response to technology changes.
So what's the distinction between making a charter change, as you're proposing, or changing the city code?
Well, the judge said that since the charter refers to operators and lodging, in order for us to have code that clearly applies to them, we first have to have some authorization in the charter.
Okay.
And even though the charter has a clause that says we get to interpret it very broadly, and we have essentially the final say, except in rare instances, the Anderson lawsuit, the court just couldn't get past the fact that operator of a hotel, motel, apartment struck him as sort of bricks and mortar, as if we're in the 70s, and less like the new world of internet business. So we had two options we could have pursued. One is we could have defined the terms broadly in the current charter provision. And the risk of that is that we might miss something. We have to come back at some point and define it, because we don't know where technology is taking us. I mean, today it's an app, tomorrow it'll be a chip in our ear, well, who knows? Or we can just put a clause in where the voters give us the authority to interpret it broadly in light of new technology. So that's the route we've gone. The net effect of this would be, if it passes, that the council can then adopt code that makes clear that an operator of a hotel, motel, lodging house, mobile home, and park, includes managing agents, includes internet matchmakers, includes all the other businesses which have spun off because of technology in this area, and will allow us to compel HomeAway to pay the same tax which all their competitors pay, and will end what is, I think, a very unfair situation of them getting a competitive advantage because they're now currently underpricing the market because they refuse to pay the business license tax or the transient lodging tax.
So this is a city charter change. The county also has a transient lodging tax. Is the county going to be? You don't speak for the county, but what's the county?
So we collect the whole thing.
Okay,
And
so
then
this
the pass-through.
charter change will be sufficient if it passes
To cover the 11.5%. And let me be clear. I'm no longer a practicing lawyer, and I'm not the lawyer in the council, right? But when you read Section 7-113, there's the plain text and there's the spirit of it. It's about lodging taxes, and it is a testament to how zealous they have been in their legal strategy. That we're actually at this moment where we have to change the charter to make clear that they're a business that is involved in the lodging business that is subject to this tax. And again, I want to emphasize that Airbnb, which is no model corporate citizen in our community, pays this tax. So there is no technology impediment to their doing it. It's just that HomeAway claims they're exempt from everything.
How much revenue do you think this charter change might mean to the city?
Well, because HomeAway refuses to tell us the identity of their hosts, so they've gone so far as to say, we won't even give you the list of our hosts so that you can go check to see whether there's a working smoke detector or things like that. We're just guesstimating. So we think maybe as many as 600 rental units. And in terms of revenue, I would put the ceiling at about $500,000 a year. And they currently owe the city a couple, maybe $2.5 million. And we still have litigation ongoing because we brought claims against them under federal, state, and local law, and the judge has allowed a couple of the claims to go forward under state law. And that's money, by the way, that would otherwise go to the general fund. So it's actually very important that we collect this money.
And does this act retroactively?
Does it what?
How does this impact the litigation over the $2.5 million?
Well, it would prospectively solve the problem. And if HomeAway has any decency, I think through a negotiation, they'll try to settle the rest. $51 million is how much we collect now in lodging taxes. So it's an important part of our general fund. And but this would settle the issue going forward, at least in terms of our ability to impose the tax, and they would just start automatically collecting and remitting like Airbnb does.
So you said the ceiling of $500,000 a year. Is that the city general fund share? Or
Yeah, well, the part that comes to us is
so
under $500,000.
Right. So between city and county, we're talking about $1 million a year.
Could be, Nigel. I just I want to be very cautious here because we have no way of knowing how big their business is, and even though we spot check these websites, all these websites to see whether people have business licenses and without the identity of the host, it's very hard for us to judge that.
So you told us that HomeAway is not a good corporate citizen. Those are my words, not yours.
Right.
How much pressure has the hotel industry put on the city council to bring this charter change?
None.
Really?
Zero. Frankly, I've had no conversations with anyone in the hotel industry. If this ended up being a big campaign, let's say that HomeAway decided to drop a lot of money. I would be foolish if I didn't go and ask people in the lodging business if they would support our effort. But I've never had a conversation. I do serve now on the Travel Portland oversight body with Deborah Kafori that looks at how the 1% is spent. And I updated them at a recent meeting that this thing is moving forward, and a couple of people harumphed. So, a couple of the competitors in the room harumphed because, and I interpreted that as they think it's unfair that everyone pays this tax and a company comes in and claims they're exempt from everything. Because it does put them at a competitive advantage.
So to make sure we've asked the complete question,
Yeah.
has Airbnb asked for this to go forward?
No.
No. Okay.
No, and I'm a little sheepish about admitting this, but once the judge said you should think about changing the charter, the city attorney came up with an approach, and since the mayor was not familiar with this issue, they asked me if I would bring it to council and explain it, which I did. Once it was approved by the council, there needed to be someone to go out and sell it. And I guess you can see I got the short straw on that. I've had no conversations with any of those companies, and you know, I have been the sharpest critic on the council of all those companies. So I haven't even met with their lobbyists when they've been, like Uber's been in the building lobbying. I haven't even met with their lobbyists, so I had no conversations.
When was the council vote to refer?
That's a good question.
Was it this year or was
Yes.
it the old council?
Yes.
It was this year. It was.
Was it unanimous?
There were only 4 members of council present, and it was a 4-0 vote, and it was May of 2017.
No, that's when that's.
That hasn't
about.
happened yet.
Oh, I'm sorry, that's right. It was.
It was recent, I remember.
Yeah, no,
I tried to put that past you.
I was curious as to whether it was the old council or this council.
No, it's
that's
this
all.
council.
So this came. I think was it January?
It's not crucial.
I'm
I
sorry.
was just curious as to whether it was old or not. So.
I think it was January.
I don't remember the exact date, but I know it was this council.
I'm sorry.
Yeah.
February of 2016. It was this council.
Then it would be February of 2017.
Yes.
But it's not important as long as it was this council.
Yeah, it was this.
So Commissioner,
Hold on a sec. Let me just see why. Oh, council meeting date was February 15, 2017.
Great.
And no more trick questions. I'm going to stand by that. I begin to sound like that guy who advised Trump on Russian affairs, who keeps going on TV for some reason and keeps giving a different answer.
so are there other flashpoints between the city government and the new economy?
Yes.
What else are there?
There's a bunch.
Can I ask him
Sure.
a like subset of that question?
Please.
So one of the critiques of the city's enforcement of Airbnb and other short-term rental legislation is that once they have the tax dollars coming in, there's less of an incentive for the city to be enforcing the health and safety code as well as getting people to pay to have those licenses.
I'm not
Does that concern you at all, that there is this kind of, that the city isn't living up to its end of the bargain on
Because-
collecting this money?
because we're getting a revenue stream.
Because you're getting a revenue stream without necessarily enforcing the
Stay tuned.
regulations.
Stay tuned. This mayor has signaled he's going to drop the hammer hard. And I think it's a fair point, and it's even more fair when you think that we've agreed to take some of the short-term rental money, fund the housing investment fund, and use it to bond. And so you could say that we have almost an institutional interest in maintaining the revenue stream. And technically, Rachel, the ultimate hammer we have is withdrawing their license. So if this thing really heated up, it's the threat of yanking their license to do business is the ultimate card, which would then cut off the revenue. The Revenue Bureau is wildly overextended right now. They have a lot on their plate. But we've made steady progress, not enough for my taste, and I think you're going to see us begin to drop the hammer a little more. So I'm not ready to say that I don't think we've made a conscious decision to go soft on enforcement of our code. But I will also say that these are the most resourceful people we've ever dealt with in terms of trying to evade community standards and legal obligations. And I view them as potentially even a harbinger of this new economy. You know, Uber going down to Salem trying to get the legislature to not only preempt us, but decide the question of the status of the drivers. You know, this is just an endless series of fights where they're trying to prevent us from doing what the public expects us to do, which is protect their safety. And I think there's some growing pains in terms of us as a regulator. But no, I don't think we've turned a blind eye because we're getting the revenue. But I think it's still a work in progress in figuring out how we drop the hammer, to be honest.
So what are the other areas in which you see the need for greater regulation and also potential revenue?
Yeah, so I mean, HomeAway is just the poster child for, taking the most extreme position. They haven't even, registered as a business in Portland. Uber, I think Uber is going to start heating up again. I believe the bill they had down in Salem is now dead. That bill would have preempted the city, would have decided the question, would have just declared that drivers are independent contractors, and would have diluted, weakened consumer protections. My understanding from a briefing I got yesterday from our legislative affairs team is that's now dead. There may be a state effort to impose a higher level of background check, and we would welcome that. Anything the legislature does to strengthen consumer protections, we would welcome. But we have not gotten much from them to date on gray ball. And so the next question the council is going to take up is whether to more aggressively go after them for their alleged conduct in 2014. So far, the city's been looking at whether there was a violation of the regulatory agreement from 2015 forward. But we may have legal claims that we can assert for all the stuff that's been revealed through news accounts in 2014, and we may have to have the council authorize a subpoena to get those documents.
Have you figured out whether the legal opinion of city lawyers is that you have the authority to do that?
I think we do, and we're going to go into executive session on Tuesday to get a briefing on all of our legal options from the city attorney.
So there are other cities that are seeking information about gray ball.
Right.
How does it work legally if they have discovery in San Francisco or they have discovery in another city? How can you get access to that discovery?
It's a great question. So I understand there's a grand jury in San Francisco. We would not obviously get that information. If there's a federal prosecutor pursuing a case, they're not going to share that. Any other regulator that's seeking that information, technically we could ask them to share it. My guess is that if Uber decides to share the gray ball playbook or something, they'll do it subject to some non-disclosure. They'll try to do it subject to a non-disclosure agreement. So while I have some hope that either through a grand jury proceeding or some other legal avenue, the Attorney General of California or whatever, we may learn more about gray ball. Locally, I think it's going to come down to what is the Attorney General doing in the state? What power do we have to issue a subpoena? And do we have legal claims that go back to 2014, which we can assert so we get discovery through a normal court proceeding? And, I said from day one, our focus has to be broader than just did they violate our regulatory agreement. Because all the reporting that's been done shows that the alleged misconduct occurred at the time they came in and operated illegally, and that would be 2014. And we filed a lawsuit to stop them, not we, the city. We hit them with discovery, and one of our discovery requests was how come the folks who are enforcing the law can't get a cab on their phone? So that would have led potentially to revealing gray ball. And I don't know if you saw, but there was a story this week. There's great reporting going on about this issue. There was a story this week where the gray ball technology was used to track Lyft drivers. So there's our hunch, my hunch has been that a company that goes to these lengths to deceive and evade, and they can use technology in such a mischievous way, could also use it to redline and screen out people. I mean, if they can track that Nigel is trying to enforce the code against them, then by definition, it seems to me they could also find a way to prevent you from accessing a ride if you happen to be an East County resident in a low, a fare that is low volume or whatever, low margin, or you're disabled or whatever. our concern is not just did they continue to use this technology to prevent us from regulating them, but did they use it to discriminate against any class of riders? And I've been told that Lyft has been pretty responsive to our requests, Uber not so much, and I think the council now has a decision to make about whether we pursue litigation and or subpoena. And the last time I'm told the council took up an issue of a subpoena was when Commissioner Stan was doing battle with PGE. And the question came up about what is our authority to compel someone to produce documents for purposes of either an enforcement proceeding or our ability to legislate. And we'll be getting a briefing on that in executive session, which, as you know, is closed to the public, but technically members of the press are entitled to be present.
So what happens if this measure, if voters are confused by this measure and or they don't like it and it fails? What happens then?
This is one of a number of tools. This is a common sense updating of our charter that gives us the authority, clear authority to tailor the transient lodging tax to technology changes as they go forward. The argument that HomeAway put into the voters pamphlet is quite remarkable. And essentially their argument, they put a statement in opposition, their argument is they're trying to do this without a vote of the people. Now that, of course, is chutzpah, because we're specifically doing this and requesting it through a vote of the people. So it's an artful message that is, I guess, designed to track, sort of the Taxpayer Association of Oregon view of the world. But we, in fact, are asking the voters to give us the permission to do this. That's precisely why we've referred this to charter. And I think it just is another example of how far they're willing to go to either evade or mislead the public. I'm hopeful that we get a strong endorsement from your paper and all the other editorial boards that review this, League of Women Voters and the like. I'm hopeful that paired with the auditor's charter referral, which I'm a strong supporter of, this will not become controversial. I think this becomes controversial if HomeAway decides to run a misleading campaign and tries to ride an anti-government or anti-tax message as a way of, again, insulating them from paying the same tax that everyone else pays, which is all they're trying to do. And again, even Airbnb pays this tax. I want to emphasize that. That says a lot, because they have not been a model corporate citizen.
Okay.
Thank you so much for.
Thank you for having me.